enough to have Dominic Gauduto with us, and he'll be introducing himself to you all in a moment. But before we start, I wanted to do a land acknowledgement. Okay, so we begin this gathering by acknowledging that we are meeting on the unceded traditional territory of the Mi'kmaq people who have lived in this region for thousands of years. The Mi'kmaq people have a relationship with this land that is deeply rooted in their culture, spirituality, and history. We honor and respect the Mi'kmaq and contributions, knowledge, and perseverance that the Mi'kmaq and all Indigenous, Inuit, and Métis people. As we come together today to discuss our work in grief and advanced care planning, as well as life planning, we recognize the profound connection between healing and land and the importance of cultural understanding and community support in navigating loss and sorrow. And may our conversation today be mindful and compassionate, and may they contribute to a broader sense of healing for all. And in this photo here, you'll see this is a drum from Alan Syliboy's Daily Drum that he posts online. And he says in his post that the whale is known to help people in need, whether they are helpless or wounded. And the whale symbolizes kindness, intelligence, and compassion. So I really see this message being really important tonight as we talk about planning, life planning, advanced care planning, and planning for the future. All right.
Okay.
Pass it right over to you. Thank you. Go ahead, Dominic.
Thank you, Beth. And I'd like to welcome you all this evening, and good evening to you. Just before I start, I'd like to tell you a little bit about myself. I'm a retired lawyer. I've been retired for about 4 years. I practiced for a period of 42 years in Sydney as a sole practitioner. So when I started my practice, I was a general practice. I did whatever came in the door. But as time advanced, my sort of specialty or my preferred areas of practice were chiefly real estate and estate planning, wills, probate, powers of attorney, things of that nature. So the other thing I want to do before we get started is I want to give you a couple of warnings about myself. As you can tell by my name, Dominic Gauduto, I'm Italian, and we're notorious for speaking with our hands. The only thing worse is an Italian lawyer, because I not only speak with my hands, but I speak with my feet. So what I mean by that is I'm not used to actually sitting when I speak. Being in court, you're always standing. That's usually my preferred position when I speak. So if you find that I should disappear from the screen, don't be alarmed. I'm close by and I will be back.
You're chatty, Dominic.
Yes, I'll do my best to stay planted here. So what I'd like to do, Beth, if you could advance to page 2. Yeah, so my topics today are going to be dealing with 3 specific documents: wills, powers of attorney, and personal directives. So if you have all these documents in your arsenal, you sort of covered all the bases necessary for advanced care planning. So we're going to start off with will, and before I proceed to wills, I'm going to deal with each of these documents separately. I'll give you an opportunity at the end of each topic to ask questions. But as Beth said earlier, if you want to ask the question beforehand, feel free to do so. In fact, I welcome it. So okay, we're going to proceed to wills. So if you would advance to the next page, Beth. Okay, so wills. So the first thing we're going to deal with is, what is a will? So a will is a document made by the maker, and the maker is known as the testator or testatrix in a will, not depending on whether it's male or female. And the maker or the testator will appoint a personal representative known as the executor or the executrix to handle the disposition or the passing of property on death. Now, there are various types of wills. There are simple wills, And the majority, like I tell you, like I'm probably drafted thousands of wills in my career. The majority of them are simple wills. So I'll give you a little example of what a simple will is. It states if your spouse uh, survives you, or if she so if she survives you, then you're going to give all your property of every nature and kind, wherever it's situated, to your spouse and appoint your spouse as executrix or executor. Uh, the will can go on one step further. A simple will can, which states that if your spouse predeceased you or dies at the same time, or dies within a certain period of time, then you're going to give all your property, say, to your children, equally, share and share alike, and you usually appoint one of your children as executors. So that's the standard run-of-the-mill simple will. But wills can become more complex depending on the circumstances. Um, if you have, say, you have young children and you have to consider setting up a trust will, um, especially if you and your spouse should die at the same time. What a trust will is, you're going to provide a trust for the education, benefit, and maintenance of your children until they reach the age of majority. You also have to appoint a legal guardian under a trust will. And trust wills are often used as well as, say, if you had a disabled child and you want to provide for that child for an extended period of time. And usually if it's a disabled child, it's for the life of the child. So as you can see, a complex will would be in place for a much longer time period than a simple will. Simple wills are usually when a person dies, they go to a probate process. From the time of opening of the estate to the time the estate is closed, it usually runs about a year, could be a year and a half on a standard probate. But with these complex trust wills, they can go on for years. Okay, so you want to advance, please. So then the next thing I'd like to talk about is who can make a will. So in the province of Nova Scotia, anyone who is of the age of majority, that is 19 years of age, can make a will. There is an exception. If you are married and you're under the age of 19, you can make a will as well. But the major rule is you got to be 19 to make a will. You also have to have capacity, testamentary capacity it's called. That is, you have to have an understanding of the nature and effect of the will. So, and when I will be mentioning these words, major, majority, or these topics, major, the age of majority and capacity, because it relates to all the documents we're going to be talking about. Okay, do you want to advance, please? Okay. No, I think you went. Can you go back one? Okay, I'm sorry. Yes. When is a will effective? I got to look at my screen as well because I'm looking at my notes at the same time. So wills are effective on death. So up until that moment, you could change, you can revoke, you can change, you can amend, you can alter your will as frequently as you change the clothing on your back. In fact, it's encouraged. If you have a will, you should review it periodically. When there are major life changes, like for example, if your executor passes away, or if one of your beneficiaries pass away, or if someone gets married or divorced, you may want to review as the circumstances change. You should review your will. I mentioned that it can be changed at any time. I certainly encourage anyone that you're dealing with, if anyone is thinking about changing a will, encourage them not to make the changes themselves. Don't do these, crossing out. Like for example, if a beneficiary died, you cross their name out of the will and pen someone else's name in. I encourage you not to do that because these changes have to be executed properly, and we'll be talking about the mode and execution of will, the proper way of doing that a little bit later. But any changes have to be executed the same way. If they're not, that change is not going to be effective. Now, so the easiest thing to do, if it's a very minor change, like I always encourage people to see a lawyer. Lawyers have been trained in the drafting of wills. They know all of the proper law that's involved. They're not going to make mistakes. And if they do, obviously a lawyer would be legally responsible. But if you make wills yourself, I had a lot of clients who would, they get these kits. They can buy kits at some of the office supply shops or online. These kits are available where you could fill in. They're actually a form, and you just pen in what you want in the actual form. And I've had a lot of cases where number one is those wills appeared in my office and they weren't properly executed. And number two was often the wording that they used was very ambiguous. And I can tell you this, in situations like that, you can almost be certain that these wills are going to end up in court with for an interpretation of a will. And I, the caution I give everyone that when I would speak to is what you want to do is, if you want to retain the value of your state, try to keep lawyers out of court, because once that's where the lawyers actually make their money. And what often happens, if an estate matter ends up in court, you may have two or three different lawyers appearing, could be even more. I mean, I've had cases where there'd be 6 or 7 lawyers, one representing each of the heirs. And the thing that people don't realize is often in estate actions, the costs are paid out of the estate. And that's, if you have 4 or 5 lawyers involved in a legal action, it doesn't take long before that estate value can be diminished. So I encourage people to see a lawyer. If the change that they're going to make is minor, it can be done with a one-page document called a codicil. A codicil will change a particular part of the will. For example, if your executor passed away, all you do in the codicil, it would state that you revoke a certain clause, the clause that where you appointed your executor, and you substitute another clause, we're appointing a new executor, and then you use the magic clause that you will confirm all the rest and residue of the will. So that's a very simple document. If it's a major change, well, then normally they will just do up a new will. Okay, so you want to advance now, please? Okay, so how are wills revoked? I said they can be revoked at any time. The chief way of revoking a will is by making a subsequent will, because the first clause of every will is, I hereby revoke all previous wills or testamentary dispositions and documents previously made and declare this to be my last will and testament. So that's the most common way of revoking a will. But they can also be revoked by simply destroying your will. You rip it up. And that's why lawyers are always insist on giving the original document, the original will, to the testator, the person who makes the will. So they have that option that if sometime prior to death, if they do not like what the will says, they have the option of destroying the will. So that's another way. The third way is actually something a lot of people aren't aware of, that having a marriage after a will was drafted will revoke that will. So if you had a will and you get married 2 years later, the marriage revokes that will, because now you have a new dependent, a new spouse. So the only way, there is one exception, that if you make a will and you state in the will that you're making this will in contemplation of your marriage that's going to occur, next month or in 2 months' time, then as long as you make that proclamation in your will, it will not be revoked by marriage. But if that doesn't appear, a subsequent marriage will revoke a will. So if you do get married, you have to then make a new document. People will ask, if marriage revokes a will, will divorce revoke a will? But divorce does not revoke the will, but it will revoke the appointment of your former spouse as executor or executrix, and it would also revoke any bequests that are made to that former spouse. Okay, so the next thing I want to talk about is the form and mode of execution. I've already sort of given you the warning that it's important that wills are executed properly, because if they're not going to be held valid. So a will has to be in writing. It has to be signed. It has to be signed by the testator, the person who makes the will. But if the testator is unable to do that for some physical reason, they're unable to sign, it can be signed by someone on behalf of the testator, but the testator has to be present and request that person to sign on their behalf. The will has to be witnessed by two witnesses who have to be present at the same time in the same room, who see the testator sign, or if the testator can't sign, the person who's authorized to sign on behalf of the testator, they have to see that signature, and they each have to see each other witness the actual document and sign the document. Now, the benefit, there is a bit of a limitation on who can witness a will. The Wills Act, and I'll tell you this, like the other two topics I'm going to be talking about, the powers of attorney and personal directives, we have fairly new or newly amended acts for those. We have the Powers of Attorney Act and the Personal Directives Act. They're fairly new. The Wills Act is the one that we're dealing with today is the same one that was in vogue when I was back in law school over 50 years ago. It's the same Wills Act. So the only restriction on witnesses is that the witness who witnesses a will cannot be a named beneficiary in the will or the spouse of that named beneficiary. Because if the witness is either the beneficiary or their spouse, then that's going to revoke or nullify the bequest to that beneficiary. So you have to be careful on who's going to witness the will. Okay, Beth, you want to advance? One of the biggest questions that I'm asked is why should I have a will? Well, my main answer is just look at the title. It's your will. It's an expression of your wishes. You have worked all your life to acquire your assets. Only you should make that decision on how your assets should be dispersed when you die. If you don't have a will, then the state or the provincial government, through their legislation, are going to dictate how your assets are distributed. We have an act called the Intestate Succession Act, and that intestate meaning dying without a will. If you die testate, you die with a will. So that Intestate Succession Act dictates what happens to your assets and how they're going to be dispersed. And it's amazing sometimes, depending on the circumstances, the difference between having a will and not having a will, the distribution can be substantially different. And I'll give you an example. So let's say we have, and just for that example, I'm going to say we're going to say we have a family of 4. We have the parents and 2 adult children. And for sake of comparison, we're going to say that the estate is valued at $500,000. So if you die with a will, and if you have that standard run-of-the-mill simple will, as I said earlier, most of those wills say, if my spouse survives me, I give all my assets to my spouse and I appoint him or her executrix. So in that situation, your spouse with the will gets the full $500,000. But if you die without a will, then you run over to the Intestate Succession Act. And what that states is, what normally happens is if you have a spouse and if you have more than one child, like in our situation, you have two adult children, the spouse gets an automatic claim on the first $50,000 of that estate. So $50,000 comes from the total estate and goes over to the spouse. It also states that because there's more than one child, the balance of the estate, that $450,000, is divided 1/3 to your spouse, and the rest goes to your children. So you take the 1/3 of the balance, is an extra 150,000. 1/3 of 450,000 balance is an extra 150,000. You add that to the 50,000 that the spouse had initially. So the spouse ends up with 200,000 as opposed to the 500,000 she would have had if you had the will. So you can see there and change, and the act goes on and states what happens if you don't have a spouse, what happens if you don't have children, and so on. So, but the point I'm trying to make is that the final distribution of the estate may not be according to your wishes, what you want it to actually occur. So it's important to have that will to assure your wishes. The other thing that the will provides is that you're going to be appointing an executor, a person who's going to be responsible for managing your estate after you die. If you don't have that will, then again, the provincial government, through the Probate Act, will appoint someone to be that administrator. And that administrator, and it does indicate in the Probate Act who has priority. And a lot of times it's what you would want, because the first person who has priority would be your spouse. But there's times where people say, well, I really don't want my spouse to be executor because she really is not that good with money, but I have a son who's an accountant and I want him to be it. So the only way you're going to make sure that that happens is to have the will where you appoint the executor. The other reason for having a will is you go through a process called probate after you die. If you die without a will, the cost of that, it's not called probate if you die without a will, it's called administration. But the cost of administration is usually more, and it's a more complex procedure than having the will. Normally, with a will, you're appointing the executor. But without the will, the actual probate courts are going to appoint the administrator. And because they appoint the administrator, that administrator's work has to be supported by a bond. Now, the bond, there's two ways of having bonds in a probate process. One is a personal bond. A personal bond will state that you really, the advantage of it is that you don't have to pay for that bond. But it's kind of a difficult thing to get because you have to have that bond has to be guaranteed by two people, depending on the value of the estate, has to be guaranteed by two people. And those people each have to have assets worth twice the value of the estate. So I mentioned if the estate was worth 500,000, each of these guarantors or bonds people or sureties who signed a bond have to have assets worth at least $1 million each. And they also have to realize that they are guaranteeing the work of the court-appointed administrator. So in the event that that administrator should abscond and take all of the assets and bugger off to South America, those people who signed that bond, their assets are going to be called upon to guarantee that the heirs get what they should have gotten. So sometimes it's very difficult to get friends or family members to sign that personal bond. And what normally happens in that situation is you have to then purchase a bond through a surety company or an insurance company, and that adds to the actual expense. Now, I talked about probate. People have often come to me and said, well, I'd like to avoid probate. I think there's a sort of a misconception that if you had a will, you don't have to go through probate, but you do. Even with a will, you have to go through the probate process. There are ways of avoiding probate, but in order to do that, you got to make sure that all of the property that you hold is held jointly with some other person. Now, if you look at your real estate, there are two ways of holding property jointly when you're dealing with real estate. Real estate being your home, your cottage, any land that you actually own. The first way of holding property jointly with real estate is what's called joint tenancy. So I encourage you, when you go home, if you have a will, if you have a deed, if you own real estate, I encourage you to pull out your deed and look at it. Look at the first page of the deed, and that's the first page should be a document. It should read like this indenture dated blank day, a blank between, and then it will describe who you got the property from, and they'll describe them as the grantors. And then it says to the grantees. And the grantees would be you and if you're married, you and your spouse. I encourage you to look at that to say where the grantee is described to be your name and your spouse. Make sure that these key words actually appear after that. It has to be as joint tenants, and it could be more specific. It could be as joint tenants and not as tenants in common. Now, the joint tenancy, the beauty of that is there's what's called a right of survivorship, so that if it has those magic words in it, if one of you die, your interest passes automatically to the other person named in that deed. It doesn't go down into your estate. It doesn't have to go through probate. It doesn't go it's not a part of your will. It passes by deed. But if your deed does not use those magic words as joint tenants, if it's silent, for example, I've had cases like this where it's silent, where the deed is in your name and your spouse's name, and that's it. There's an inference in law. If it's silent, that now is what's called the second way of holding joint property, tenants in common. It's not a joint tenancy deed, it's a tenants in common deed. And what happens there is if one of you die, your interest does not pass to the other person named in the deed, it goes down into your estate. So therefore, it has to be probated. So you got to make sure that all your real estate is in joint tenancy. You also have to make sure that all of your other assets, your personal property, the main ones being your money in the bank, any investments that you may have in the bank, they all have to be held either jointly or you have to designate specific beneficiaries for those. Otherwise, what's going to happen is if you have a bank account just in your name, that has to be probated. So there are ways of avoiding probate, but then there's also some risks involved in doing that. And I'd like to express those to you so that you would be aware of it. See, the difference between transferring property by will and transferring it by, say, deed is that the transfer is postponed until after death. After death and the probate process, the will then becomes recorded at the land registration office and title then passes to your beneficiaries. But with a deed, if you do it by deed, title passes immediately. So if I've had situations where when you see it often is where a senior would come in, the senior would have just lost their spouse. And so they come in and often they've gone through the probate process. They may have gone through it when their spouse passed away. And they say, I want to avoid this when I pass away, when I die. And I understand that I put my property in joint tenancy with my children, then I don't have to, the home doesn't have to go through probate. It will pass automatically to my kids. And that's true. So I had a situation where an elderly lady came in and said, I want to do this. I want to avoid probate. I want to put the property in my name and my 4 children as joint tenants. So we went ahead and did that. But then she came back about 2 years later and said, look, you know what? I changed my mind. I think I want my property back. I want to sell it. And I want to go down and live with my daughter in Florida. So the first thing, luckily in this situation, the children were willing to sign the deed back to the parent. Because that could happen. That's another risk when you put it in joint names, is you may get a child who says, oh, wait a minute, I now, in this case, I now own 20% of the home. I'm not going to sign it back to my mother or to my father. But that would prevent the actual sale of that property, because you have to be able to transfer 100% title to the person who's buying it. But in this particular situation, that didn't occur. The kids were willing to sign it back. But what was discovered afterwards is that there was a lien or a judgment against one of her children. Her son had a judgment of about $40,000 against that particular property. And what happened is the judgment actually came on after the transfer of the deed. But once a deed is recorded at the land registration office, if a judgment is obtained and it's recorded at the land registration office, it attaches to any property in that person's name. So that $40,000 attached to the mother's property because it was in the son's name at that particular time that the lien was recorded. And that lady couldn't sell that home until she paid the full judgment off. So there is some risks. So you have to weigh the pros and cons of either trying to avoid probate. And I try to tell people too that the cost of probate is not prohibitive. There are two fees you have to pay in probate. One is the probate tax, which is sort of a tax, and that's based on a percentage of the estate. Now, it's a government fee that you have to pay to the government, and it's usually somewhere in the vicinity of 1 to 1.5% of the value of the estate. And then there's the legal fees you have to pay for the probate process, and that's usually in the same range. So for about, for a maximum of about 3% of the estate, you've got this security that you could, I would certainly advise in situations where people want to put the property in their joint names with their kids. I would, recommend that they do not do that. Go through the probate process. Mind you, if it's just a happily married couple, we encourage putting everything in joint names because you're living under the same roof. You know the financial health of your spouse. You would know if there's any kind of liens or like if sometimes you have a spouse who has problems. So maybe in situations, if you're happily married, we usually encourage joint tenancy and putting everything in joint names to avoid probate. But in situations where one spouse has passed away, there is that risk factor. Okay, so that's about all I want to say about wills.
Great. Dominic, we actually have a question.
Yeah, I'm sure. Okay, go ahead.
Thank you for that. My quick question was just about wills with respect to life insurance policies. If people have life insurance policies and they have already kind of confirmed who's to get what and what percentages, would lack of will supersede that?
No, that the actual life insurance policy will designate beneficiaries, specific beneficiaries, and that's just like the joint tenancy in the deed. The actual life insurance policy will pass directly to the beneficiaries on death. It's not considered an estate asset and doesn't have to go through probate.
Okay.
So whether you have a will or not, if you have the designated beneficiaries, it's going to fulfill what you want. It will pass automatically on death to the beneficiaries.
And would it facilitate having or avoiding probate if you had a kind of like a family trust where everybody was named so that it didn't have to be a problem and everybody could just have the things come to them naturally?
You can, like family trusts or other like sort of a more complex document, but yes, that would have the same sort of effect. What family trusts usually do is the property is usually transferred to the trust prior to death. So when the person dies, they really don't own that property. It's held by the family trust. And that's one way of keeping properties in a family for generations to come. So yeah, I guess what I said, that to avoid probate, you got to make sure that everything is held either jointly or you have specific beneficiaries named. Yeah.
Okay, perfect. I'm so sorry I joined a couple of minutes late, but Mr. Dominic, if you're still practicing, can you push your business card next to that? I think I need you.
Yeah, unfortunately, I'm not practicing. I retired 4 years ago, and I'm quite happily retired, and you cannot convince me to go back.
All good. Respect.
I just have a quick question. It's Shelley. Do you have any recommendations as far as how many executors? I often see, parents, if they have 3 children, they want them all to be joint executors or 2. Is it simpler and more practical?
Yeah, I think you froze up. Can you hear me? I'm sorry,
Yes.
you froze up for a minute there.
Oh,
I got.
Did you hear the question?
I got a lot of it. You were talking about the number of executors, and but I didn't catch the end of it. Yeah, you froze up again.
Maybe you could put it in the chat, Shelley.
Yeah.
Oh, you're
Well,
back.
anyway, I can
Oh,
tell
I'm
you.
back?
Yeah, but you're freezing up in midstream, so I'm not getting the end of your question.
Okay, I'll put it in the chat. I was wondering if you had recommendations about the number of executors. Often
Okay,
parents
well,
will put all 3 children.
You can. I mean, that's a personal decision. I find sometimes that's difficult because all 3 have to agree on whatever is going to be done. You usually you guys should have at least one, and you can appoint an alternative if the first person's unable or unwilling to act. But yeah, there are situations where people say, oh, well, I want all my not all my children, but 2 kids or whatever. But so there's no set rule. I always feel number one is you should try to appoint someone who has some sense with finances, and also someone who is close by. Like it's better to have someone who lives in the same area that the testator would live, because that probate process takes, as I said before, even the standard probate could run a year and a half, and that particular executor was going to be responsible for accounting for all of the assets, making sure all the bills are paid, and then doing the final distribution on the closing of the estate. And so they have to be available, readily available over that year or year and a half. And it's much easier if they reside in the jurisdiction where the testator lived. Yeah. Okay.
Any other questions? I think we're moving on to power of attorney next. Is that?
Yes.
Yeah.
Okay, so you want to just put that slide up, Beth? Okay, so powers of attorney. So what is a power of attorney? So it's a legal document in which the maker is known as the donor, will appoint a representative. The representative is known as the attorney. It doesn't have to be a lawyer or an attorney. It could be a family member, a friend, but they appoint an attorney to handle all of their financial matters, including their property. So it's a document that chiefly deals with financial matters. Again, there are different types of powers of attorney. There's what's called a special or a specific power of attorney, and that deals chiefly with one actual task. And it's for usually a limited period of time. Like an example of a specific power of attorney is, let's say you were in the process of selling your home, but you're called out of the country on work, and you're not going to be available or not going to be here when the closing of the sale of your home is going to occur. So what you can do is prepare a specific power of attorney where you appoint an individual to be able to sign the deed on your behalf and to do everything that's necessary to transfer the title and do the closing. So it's specific and it's limited because it only lasts for a short period of time. But the type of power of attorney that we're going to be dealing with now is what's called a general power of attorney, and more specifically, an enduring general power of attorney. So the general power of attorney, it's not one specific task, but whoever you appoint as attorney can do anything that you could have done, or anything that you can do concerning your financial matters. And the enduring part means that even if you lose capacity, if you're no longer able to manage your own financial affairs, the power of attorney endures throughout that capacity. So that's the document that we're going to be dealing with. So who can make a power of attorney? I mentioned before that I'm going to mention again with personal directives that it could be anyone if they are of the age of majority, and with 19 in Nova Scotia. And secondly, they have to have capacity. And under the Power of Attorneys Act, the new amendments to the Powers of Attorneys Act, they're helpful when they kind of define what that capacity means in relation to powers of attorney. What they state is the person who is making the power of attorney has to have an understanding of the nature and effect of the document, including they have to understand the type of property that they own and the value of that property. They have to understand that you owe an obligation to dependents. You have to understand that the person that they appoint will have complete control over their finances. That person could, sign a deed and sell the real estate out. They can access the money in your bank accounts. They have to understand that they have that complete power. So there is a possibility that an attorney could misuse that power. They have to understand also that they could change that power of attorney or revoke it at any time prior to them losing capacity. But once they lose capacity, they can no longer change that document or revoke it. So if they don't have that understanding, as it relates to all of these elements, they do not have the capacity and cannot actually execute the document. So they have to have that in order to sign the power of attorney. Okay, do you want to turn the page, please? Okay, so when is a power of attorney effective? It usually is effective at the time that it's signed, unless you specify in the document that it only comes into effect once you lose capacity to manage your affairs. Now, all enduring general powers of attorney will specify that. So basically if you have an enduring power of attorney, it'll only be effective once you lose capacity. In the power of attorney, you can appoint someone who will make the determination of whether you have capacity or not. That's an important thing to do. And you can specify, if you don't specify who's going to make that determination, it's usually a medical practitioner who knows you and can make the determination whether you have capacity or not. Okay, so who can act as an attorney? Again, the attorney has to be of the age of majority, has to have capacity, cannot be anyone who has been convicted of a crime of dishonesty, cannot be anyone who is an undischarged bankrupt. And if you're not aware of bankruptcy, the process of bankruptcy, that when you have a heavy debt load that you can't manage, you can declare bankruptcy, and that's a court procedure where a trustee is appointed. If you go through all of the procedures at the end of the actual bankruptcy, court will grant a discharge, and if that discharge is granted, then your liabilities are forgiven. You're no longer responsible for those. But if you are an undischarged bankrupt, your liabilities still exist, so they cannot serve as an attorney under a Powers of Attorneys Act. It can't also be anyone who's providing health care or support services for compensation, unless, of course, it's an immediate family member that is allowed, because there's always that chance of abuse that they be paying themselves a lot more than what they're entitled to. So basically, that's who can act as an attorney. Now, the attorney has to be executed. We're talking about the form and mode of execution. Just as a will has to be executed a certain way, so is a power of attorney. It also has to be in writing and dated. It has to be signed by the donor, or if the donor is unable to sign, it's signed by someone on behalf of the donor and at the donor's request and in the presence of the donor. The person who signs on behalf of the donor cannot be the named attorney. And the document has to be witnessed by 2 witnesses. The witnesses cannot be either the attorney or the person who signs on behalf of the donor or their respective spouses. So you got to make sure that it's actually executed properly in order, because if it's not executed properly, it will not be considered valid. So the last thing I want to talk about in this section is sort of safeguards. As I said before, when you appoint an attorney, obviously it's got to be a person of trust, because they're going to have complete control over your assets once you no longer are able to manage those assets. So there are certain safeguards that are built in under the Powers of Attorneys Act. In the document, you can appoint a monitor. The monitor is someone who is responsible for checking on the work of the attorney. The monitor can ask for documentation to support the work that the attorney is doing. They could ask for an accounting from the attorney. The attorney would then have to provide the actual whatever assets and the value of the assets that existed when the attorney took over the responsibility of managing the estate. The attorney also has to disclose all of the transactions, all of the bills that they've paid, supported by bank statements, by the copies of the bills, receipts, proof of payment. And the attorney also has to show the final value and listings of assets, and it should all balance to the cent. So what was there when the attorney took over, all the transactions, all the monies that were paid out, what's left should all work out. So you've got those safeguards. If you get an attorney who's hesitant in disclosing that, the monitor has the power to be able to make an application to the courts for a court order forcing the attorney to make that disclosure. So there are certain built-in safeguards. Okay, so you want to turn the page, please, Beth? Okay, so what happens if you don't have a power of attorney? And this is the specific reason for having the document. Because if you don't have a power of attorney, then the only option that your family members have is to, and it means using another piece of legislation. It's called the Adult Capacity and Decision-Making Act. An application has to be made to the Supreme Court of Nova Scotia to have someone appointed as your legal representative to be able to carry on your financial matters. That is often coupled with a determination of capacity. So doctors have to be involved in this application. It can be a very expensive and very complicated. But the important thing is it can all be avoided if you have the power of attorney. The power of attorney document will supersede, and then you have appointed your representative in that document, so you wouldn't have to go through this other piece of legislation. So basically, that's the reason why you should have the document. So that's probably all I want to say about powers of attorney. Is there any questions on powers of attorney? No? Okay, it's clear as mud, I guess, is it? Okay, so now we'll move on to the final document, personal directives. You're probably you probably have certain knowledge in personal directives since you're volunteering in this program, so to speak, but so you're probably going to know most of what I'm going to talk about. So what is a personal directive? Again, it's a legal document in which the maker, known as the maker, will appoint a representative known as the delegate, who will make personal care and healthcare decisions on their behalf when they're no longer able to make that decision, when they no longer have the capacity to make that decision. So who can make a personal directive? Again, the person has to have capacity, but there is no requirement for like the age of majority requirement. Under the Personal Directives Act, even a mature minor, someone under 19 years of age, can make a personal directive. So who can act as a delegate? The delegate that's appointed under the Personal Directives Act should be of the age of majority. There is an exception where if it's your spouse and your spouse is under the age of majority, that person can act as a delegate. The delegate has to have capacity, and they cannot be providing care services for compensation unless it's a spouse that's appointed as directive, and the spouse is or a relative who's providing those care services. And if there's any compensation to the delegate, it has to be specified in the personal directive what the compensation is going to be. And obviously that will approve that particular function. Okay, you want to then next page, please, Beth. So when is a personal directive effective? It's effective on the maker losing their capacity. So once capacity is lost, then the personal directive becomes effective. The document itself is just like the wills and powers of attorney. There's a mode and a form that has to be followed. The mode of execution has to be followed. Again, the document has to be in writing and dated. It has to be signed by the maker, or if the maker cannot sign it, by someone authorized by the maker and in the maker's presence. The person who signs on behalf of the maker cannot be the delegate that is named in the personal directive, or cannot be a spouse of the delegate. The document, the personal directive, has to be witnessed by one witness, and that witness cannot be the delegate or the person who signs on behalf of the maker or their respective spouses. The witness has to be of the age of majority and have capacity as well. Okay, you want to turn to that next page, please? So what goes in personal directives? The content. You have to at least appoint a delegate or an alternate delegate. And the same thing applies in powers of attorney and wills. You can appoint your executor or your attorney, and you could appoint alternates as well. So in the personal directive, you would at the least you have to appoint a delegate or an alternative. But I would certainly encourage people to be more expressive and give more instructions concerning their values, their beliefs, and their wishes, specifically concerning, healthcare decisions, and also personal care. But in healthcare decisions, whether you want, life support at end of life, or whether you want to die naturally, these are the kind of things you should be thinking about. I drafted a lot of personal directives, not so much the separate document that you would probably be familiar with, like the forms that you've probably seen, the booklets that are out there for advanced care planning. Where I drafted most of them, and most lawyers drafted them, under the Powers of Attorneys Act and the Personal Directives Act, there are provisions that allow personal directives to be included in enduring powers of attorney. So it was in drafting those enduring powers of attorney, I'd have discussions with clients concerning personal directives. And the first thing I'd always impress upon them is they should give some thought to establishing a minimum acceptable standard of quality of life. You have to think about, where is your threshold? My experience has been the majority of people will have a threshold that says, once I am no longer able to recognize my family or to carry a conversation on with my family. In other words, they're in a sort of a vegetative state. They will state at that time, if something happens to me and for example, if my heart stops beating, I do not want resuscitation. I do not want any type of life support. I do not want a ventilator to breathe for me. I don't want a feeding tube so that I don't want anything that will prolong my dying process. Majority of people have that threshold. They'll certainly state that, if I slip below an area where I can no longer recognize my family, no longer carry on a conversation, I do not want life support. But I found that there were a substantial number of people who had a higher standard of quality of life. And these were usually senior people who were very active in life. They were very, very independent and self-sufficient. And they would often state that, look, as soon as I'm no longer able to care for myself, if I have to have someone assist me to going to the bathroom, or assist me in dressing myself, or in feeding myself. And some of them were even to the point of saying, well, if I can no longer do the things that give me joy in life, then that's my threshold. If I slip below that, then I do not want life support in a situation where, my heart stops beating, or I stop breathing. But there was also a small, weren't many. I can think there's probably no more than a half a dozen of the hundreds and hundreds of powers of attorney with personal directives that I prepared. There was probably about a half a dozen people who actually were, I don't know if they had a great fear of dying, but what they just stated was that they wanted doctors to do whatever they possibly could to prolong their life, even if they were in a vegetative state. They wanted life support. So I encourage people to think and establish your own minimum standard of quality of life, and more importantly, once you have that, to express it in the personal directive. Express your values and your beliefs and your wishes concerning things of that nature. The personal directive can also include the persons that the delegate has to consult with in making the determination of whether you have capacity or not, and the people that should be notified when the personal directive is going to come into effect, when the delegate's going to take over making those personal care and healthcare decisions. Once you lose capacity, you can specify who has to be notified and who has to be consulted in making that determination. The personal directive can also state who you do not want to be notified, certain family members, and you may also state that you don't want them to make any decisions on your behalf. So you can be quite specific with that as well. So basically, all of that should go into the document. The more you can put in it, the better. So what happens if you don't have personal directives? Well, the actual act, the Personal Directive Act, provides for statutory decision makers. These are your nearest relatives, and they list them in priority. And the top is your spouse, and that includes common law spouse or registered domestic partners. If you don't have a spouse, then it's your children. If you don't have children, then it's your parents. If you don't have parents, it's your siblings. If you don't have siblings, it's grandparents, then down to grandchildren, uncles and aunts, nephews and nieces, right down to the point where if you do not have any immediate relatives, and I don't think that would ever actually occur, but if they cannot contact any immediate relatives, then the decisions on medical decisions and personal care decisions are going to be made by a complete stranger. That's the public trustee, who is a person that holds that office in Halifax. The public trustee would make those decisions on your behalf. So these nearest relatives, or these decision makers in situations where you don't have a personal directive, they have to have had some contact with the maker in the preceding 12 months. The only exception is a spouse. If a spouse is out of the country and hasn't had contact with their spouse, they still can make the decisions. But anyone else down that list of priority, they have to have had contact with the maker in the preceding 12 months. The person who is actually going to assume that responsibility has to be willing to take on that job and that responsibility, and that person has to know of no one who has a higher priority or higher ranking in that list that I mentioned. So this is what goes into personal directives. But if you have a personal directive, and if you're specific with these, is fine. If you have a personal directive that only names a delegate, and that's all you want to happen, I would encourage people to have, and you probably heard it, have that conversation So you have that conversation with your number one, your delegate that's appointed, all of your possible statutory decision makers, your nearest relatives. You should have the conversation with as many of those people, expressing your wishes and your beliefs and your values concerning things like life support as opposed to natural death, concerning personal care. If you want, once you lose capacity, whether you want to remain in your home, or whether you want to be put into a continuing care facility. These kind of decisions, I encourage you to speak to as many of your possible decision makers, to inform them for two reasons. One is that then they will be aware of what your wishes were, but more importantly, the person who's called upon to make those decisions will, at least it'll be easier for them to make it. For example, if you're quite expressive how when you don't want life support, that person has to make that decision. And it's far easier on someone when they know exactly what you want. And they're not forced to make that decision based on what they think you might have wanted. So that would certainly be the reason for having that conversation. Okay, so that sort of brings us to the end of this presentation. Do we have any questions on anything?
I do have a question. It's Shelley. Just regarding the practicality of having the personal directive, I guess, with you. This stems from questions I've had from people, as in someone goes into hospital. And I don't know, I only have personal experience of, I've been asked, I think my very elderly mother fell and broke a hip, and I was asked who the decision maker was. And they just simply copied down my name. They didn't require to see anything. I've had other people ask me about, a family member had a stroke, went into hospital, got the clot busting drugs, which they didn't want. But I guess that's having your substitute decision makers sort of being right there with you to speak for you. Is it a regular practice for medical practitioners to ask to see a personal directive?
Yeah, it depends. I mean, like if it's an emergency, and if you're rushed into the emergency, and the doctor there is a duty upon them to request whether there is a personal directive. That's why some people will have a little card in their wallet to indicate that there is a personal directive. So the doctor would certainly attempt to find that directive. So in emergency situations, if there's no one to actually, give the doctor directions, there's a duty upon them to actually put you on life support, to intervene with medical interventions, even though you may not have wanted it. So normally, if it's not an emergency situation, at least it's been my experience with family members and with clients as well, that once they go into the hospital, one of the first, and if they're at coming close to the dying process, one of the first questions they ask is about personal directives, what their wishes are concerning things like, whether they should be resuscitated or things of that nature. So it's always good to have it. If you have a personal directive, give a copy to your doctor, give a copy to whatever family members that are going to be making the decisions, obviously the delegate. But at least be able to have that document so the doctor can rely on it. But that's one of the reasons for having that conversation, because there's going to be some family members that are going to be there in that emergency ward. And when the doctor goes looking for instructions, someone's going to come out and say, well, I know mom or dad did not want this or did not want that. So they'd be able to give the doctor those directions. Yeah. And I know that even to the point of, if you're going on vacation, take your personal directive with you, because if you don't know what's going to happen wherever you may end up in a hospital in some foreign country, but at least that would be there. I don't know how helpful it would be, but at least they would have hopefully someone that they can be able to contact to give them the consents. Yeah.
Good, thank you.
Okay. Any other questions? Well, okay. You've been a good good audience. I hope I've been a good speaker. I hope I haven't confused you. I hope I've been clear enough, but sometimes you forget that some of these things can't be.